A lasting power of attorney is a legal document where the person making the document, the donor, appoints attorneys who are able to help them with their property and financial affairs or their health and welfare. There are two types of lasting power of attorney, one for property and financial affairs, which can take effect both when the donor has and lacks mental capacity, and one in relation to health and welfare that can only take effect if the donor lacks mental capacity to make the decision in question. Lasting powers of attorney are important because there is no legal right for anybody to help any adult with their affairs, and this applies regardless as to the relationship to that adult. This can cause significant problems if somebody needs assistance with somebody because there is no authority to do that. Having a lasting power of attorney will mean that there is somebody or some people appointed to help that adult with those decisions, and it can be incredibly worthwhile and useful. There are two different types of lasting power of attorney. The first one relates to property and financial affairs. This enables the attorneys to make decisions subject to any restrictions within the document about the donor's property and financial affairs. This can include things, for example, like speaking to banks, selling a property if necessary, dealing with income, utilities, investments, pensions, all that sort of thing. The second type is in relation to health and welfare. Lasting power of attorney for health and welfare enables the attorneys, when the donor does not have capacity to make the decision themselves, to make decisions about that person's health and welfare, and this can include making decisions about life-sustaining treatment. The attorneys can make decisions about what treatment the person receives, what care they receive, where they live, and can also do things like speaking to the doctor, social workers and other health professionals. You can't make a lasting power of attorney until you are at least 18, but they can be very useful for younger people. We never know if we're going to be involved in an accident or have an illness and lose our mental capacity and need assistance. More relevant here are cases where people may need a lot of help in the future, are beginning to lose or have fluctuating capacity, or are turning 18 and the powers that their parents had to help them change. If lasting powers of attorney are made as soon as possible, they can reduce a lot of stress and financial hardship on all parties. Lasting powers of attorney are also relevant for parents. If they lose capacity or need help with something and there is nobody to do that for them, that can impact on the wider family as well. Who you appoint as your attorney is entirely your choice. A lot of people appoint parents, children, other relatives. However, you can also appoint professionals, and here at Irwin Mitchell we do have a trust corporation who can act. Although it is your choice, you do need to think quite carefully about who you appoint as your attorney. You need to think about what skills that person has. For example, there's no point selecting somebody who can't manage their own finances to manage yours, and there is no point selecting somebody who would fall apart in a crisis to make decisions about your health and welfare. If you're appointing more than one attorney, you need to think about if those people can act together. If they can't act together, you're going to have problems. The key thing is that you trust your attorneys. You're giving them a lot of power, and you need to make sure that you trust them to make the decisions that are right for you. Lasting powers of attorney are governed by certain rules. For example, in relation to health and welfare, they can't be used unless the person lacks capacity to make the decision themselves. And in relation to health and welfare, your attorney can't do things like amend a person's will, and there are quite strict rules on gifting. You can also include your own rules and restrictions, and there are provisions within the document to enable you to include guidance or instructions for your attorneys. You don't have to include these guidance or instructions, but they can be useful, and guidance is used quite widely in the health and welfare documents. This is particularly useful because it gives your attorneys an idea of what sort of care you would like if you couldn't make the decisions yourself. Once the documents are valid, they can be used straight away, provided that the donor lacks mental capacity. If the donor still has mental capacity, the health and welfare document can't be used. The property and financial affairs document can, however, be used should the donor request that it is. Ultimately, the attorneys have always got to act in the donor's best interest, and if the donor does not want the document to be used and they have the capacity to make that decision, the documents can't be used. Once the lasting powers of attorney have been signed by all parties, they need to be registered at the Office of the Public Guardian. The Office of the Public Guardian are currently taking around 20 weeks to register the documents, but that can vary. The documents can't be used until they've been registered, so it is important to plan ahead and make sure you don't leave it till the documents are needed. If a person doesn't have the mental capacity to prepare a lasting power of attorney, an application can be made to the Court of Protection to be named as that person's deputy. The court will assess the application and if they deem it appropriate, will issue a court order naming that person as deputy. Deputyship orders can be for both property and financial affairs and for health and welfare. However, they are often restricted, and particularly in relation to health and welfare, the powers under the deputyship order will not be as wide as that under lasting powers of attorney. The process also takes a lot longer and costs a lot more than preparing lasting powers of attorney. We're always happy to speak to people about lasting powers of attorney and to help them decide whether or not this is something that they should do. It's always worth speaking to people because you don't want to leave it too late and find out that you should have prepared the documents but simply didn't get around to doing them.